Dear colleagues, I'm glad to meet you at the International Conference on Company Law that is held in for the framework of Visegrad, a small grant financed by the Internet Visegrad Fund. And for the inviting speech, I would like to invite Professor Olga Zozulyak. Professor Zulyak, the floor is yours, please.
Good afternoon, dear colleagues. Thank you, Alexander, so much for the opportunity to welcome all our participants of the 22nd conference dedicated to the theoretical and practical problems of legal regulation corporate rights according to legislation of Ukraine passed to European standards. And I would like to mention that right now we are working at the second session, and first session of our conference is working here in Ivano-Frankivsk in the walls of Institute of Corporatelaw National University. And I am so happy today to welcome all participants from different regions of Ukraine, from Kharkiv, from Kyiv, from Lviv, Ivano-Frankivsk, and they representative different scientific schools of corporate law. And also, it's great pleasure for me to welcome participants from abroad, from Poland, from Uzbekistan, from Czech Republic. And I must say today, and use this platform also to reminder for all our participants, especially from abroad, that all Ukrainians right now and all scientists in Ukraine work and live in so hard circumstances because of war. Everyday shelling, rockets, strikes, lack of electricity, lack of quality internet connection. And for us, such events is ability and opportunity to understand that we are not alone today, that we can continue our work and continue to investigate important problems of corporate law with amazing support of international colleagues. It's so important for all of us. Thank you for that. And also, let me tell a few words about laboratory of corporate law, because I would like to mention that during almost 20 years, team of laboratory investigate problems of corporate law. And I would like to mention that laboratory is a structured department in the Institute of Private Law and Business after academician Burchak of National Academy of Legal Science of Ukraine. And our department was established in 2008 when between Scientific Institute of Private Law and Business and Corporatelaw National University was signed a contract about scientific investigation and about creation on the basis of the Corporatelaw University Laboratory of Corporate Law. And during all this time, team of laboratory have investigated a lot of problems of corporate law and took part in the different scientific national and international events. And we have published a lot of monographs, scientific articles, and let me mention some of them. First of all, I would like to name monograph Corporate Law of Austria and Ukraine, 2015 years of publication, Corporate Law of Poland and Ukraine. During wartime, our team have investigated problems of implementation and protection corporate right at the legal regime of emergency and natural law. And it's also so important for us to investigate these problems. And right now, Ukraine has the status of the candidate for membership in European Union. And also for us are relevant topics dedicated to the adaptation Ukrainian national legislation in the field of corporate law to the legislation of European Union countries. And right now, we try to investigate problems of legal status of companies in European Union countries. Also investigate questions of contractual regulation of corporate relations in European Union countries. We investigate questions of digitalization in the field of corporate relations and other relevant questions for Ukraine because we try to improve our corporate legislation to the principles and standards of European Union legislation. And also, let me tell a few words about current state of legal regulation of legal entities according to legislation of Ukraine. And I would like to mention that during a few years in Ukraine, we have the process of updating and improvement civil code. And our scientists and lawmakers try to make a lot for make these improvements. And we have concept of updating civil code of Ukraine. And in this concept, we can see trends of legal regulation, also corporate relations, and also we can see trends of legal regulation, legal status of legal entities, and especially business entities and non-profit entities. And it's so important for us to improve, especially provisions of civil code, because civil code is important act in Ukraine which can regulate all questions dedicated to the legal status of legal entities, classification of legal entities, and other important questions. So in conception of improvements of civil code, we can see some trends of development, status of legal entities, and I would like to mention that in the concept we have closed a list of legal forms of legal entities, associations, and institutions, and it's important for us to develop civil code in this way. Also, we have more correct criteria for classification legal entities into entrepreneurial legal entities and non-profit legal entities, and for understanding corporate rights. In 2020, 22nd, we have opportunity to adopt and to adopt legal term concept of corporate rights in the civil code of Ukraine. And right now, in civil code, we have legal conception of and term of corporate rights. And of course, also in Ukraine, we have the process of improvement and updating other legislation in the field of corporate law. Among the important in the business sphere, I would like to mention law on Ukraine on business companies, law on Ukraine on joint stock companies, and also on limited liability and additional liability companies. Yes. I hope you can hear me.
Yes, everything is okay with a voice.
Okay.
Everything is okay.
Thank you. And also, I would like to say that idea I want to back to the brief overview about laboratory as well. And idea of creation laboratory belongs to two famous scientists in Ukraine, academician Vladimir Lutz and Professor Valentina Vasilyeva. And this conference is the first conference with the name also Vasilyevsky readings. I can say in Ukraine, Vasilyevsky readings, yes. We try to develop all investigations of these scientists right now in laboratory with our team. So thank you so much. I want to say thank you for all participants once more. I want to wish for all of us amazing discussion and good work in our section and good discussion after our when our participants will have opportunity to represent their reports. Thank you so much.
Thank you for your speech, Professor Zulyak. Thank you for your words. Before we start the first report of Dr. Tloustova at half one in Kiev, I would like to mention several organizational aspects. Professor Majdanek will join us a little bit later. So the first report will be of Dr. Tloustova. And before that, I would like to mention that please, all the participants, according to our schedule, our reports should approximately be near 10-12 minutes, and I propose to make a discussion and to have questions and answers afterwards, at the end of the first session. So, for example, several our reports, and before the pause will be announced, we will have time for questions and answers and for the discussion concerning the reports and all aspects of our topics. I also, in continuation of Professor Zulak's speech, I would like to thank all our participants from abroad, from Czech Republic, Dr. Tloustova, from Poland, Dr. Mateusz Żaba and Dr. Dominik Mizerski, and our friends and colleagues from Uzbekistan, Dr. Utkerbek Holmirzaev and Mahsuda Tajibayev, and of course our Ukrainian participants that every year connect and join our conference. It's a great pleasure for us, and it's an honor that you maintain our conference. It would be really interesting to look at your topics and to hear your topics, because Czech and Polish experience is especially necessary for our Ukrainian path in the framework of Euro integration, and also especially interesting Uzbekish in experience of reforming of company law, because earlier Uzbekistan and Ukraine were the path of USSR, and that's why it would be really interesting for us to look at your path of reforming your commercial law and company law. In fact, that's all what I would like to say. And Dr. Tloustova has warned us that her report will be without video. Dr. Tloustova, the floor is yours. Please.
Thank you very much. Hello to everyone. I really apologize. On my great Ultrabook, now the camera doesn't work, or even external camera doesn't work, so I can see you, but unfortunately I am not able to switch the video on because of some technical problem. My topic is, however, liability of corporate officials under Czech law. And under Czech law, Corporate officials include elected members of a statutory body or members of a supervisory body of a company or procurist of a company. Corporate officials under Czech law must act with due care, which is a kind of term we use, also it's stipulated in a law, in their function during the whole performance, during the whole term of their function. Legally, when we say acting with due care, what does it mean legally under Czech law? It means performing a function with a necessary loyalty, which means to the best interest of a corporation. Second, performing the function with a needed knowledge, which means acting by own capability, or if a statutory body, an official needs some advice or is not sure about how to solve certain business issue, he or she must ask for external advice. So then he's got all the needed knowledge he needs for making a decision on a daily basis when representing a company. And the third point is acting with a diligence, which means acting as a member of a body carefully. So these 3 points, necessary loyalty, a needed knowledge, and a diligence, means acting with due care under Czech law. What does it mean, or what happens if there is a breach of a duty to act with due care made by a corporate official? Legal consequences of breaching a duty to act with due care means that the corporate official is by law liable for the following areas. First is a damage liability of a corporate official for the damage he would cause to the company by not acting with a due care. Second is a liability of a corporate official for company's debts in case the creditors cannot enforce the debts otherwise. The third one is an obligation of a corporate official to release a gained benefit in case an officer would be gaining any benefit. And I will talk about it in a minute, slightly in more detail. And next point, or next liability or consequence, is a removal of a corporate official from a position by CURD. And the last one is an option to recall a corporate official from a position by the highest body of a corporation, which is typically a general meeting. So these are the consequences. What happens if there is no action or not acting with a due care? And in practice, it happens from time to time that the corporate officer does not act with due care, as acting with a due care is really, under Czech law, means really high responsibility and high level of daily operation and daily business decision-making processes which the corporate officials must make on behalf of the companies where they were elected. If I now follow up on the damage liability, what does it mean? It's an obligation of a corporate official to remedy damages which the official would cause to the company by breaching the duty to due care. And the official must remedy both material damages and immaterial. Material damages, as you probably know, it means any financial loss or any loss in assets, any monetary loss, basically. While immaterial damage can be, for example, based on inappropriate acting by the official, can, for example, be loss of company's reputation, which is in today's global world, very important. And you can build your reputation for 20 years and lose it in 1 minute by some inappropriate action or by some fraud conducted by a corporate official. The corporate official, however, under law has a right or chance to free up from damage liability in case that he would or she would prove that there were some extraordinary, non-predictable obstacles So such an officer could not act for these serious reasons with due care. These reasons can, however, be within the private area of the official, because then it's not included in for potential freeing up from the damage liability. Damage liability is quite a important and serious issue, and not easy. The officer can really conduct a huge and cause huge damage. So then it's up to the company and owners of the company how they want to settle the damage with the damage with the official. The law allows a settlement agreement to be entered by the official with the company, but this settlement agreement on remedying the damages must be agreed by 2/3 of the votes of the general meeting or of the highest body. So yes, the owners are always involved in sorting out what to do in order to get paid the damages. Or alternatively, the owners of the company can file a lawsuit to a court requesting the damages to be paid by these guilty corporate official. Second point, as the legal consequence I've mentioned, is the liability of an officer for company's debts. This is applicable in case there are some creditors who's got receivables towards the company where the official is in his or her function, and actually in order to ask the official to remedy the company's debts against or towards the creditors, there must be one step taken by the creditors upfront, which is a process of an enforcement of the debt or receivable from the company before an official would step in and be liable for paying it. What's important to say, and it's applicable for both damage liability and for the liability for company debts, is that the corporate official under Czech law is liable for any damages caused to the company by all his or her personal assets. So all his fortune, he is kind of guaranteeing for settling any damages caused to the company or creditors. So then every corporate official should think through whether he wants to take this position or can allow to take such a position and perform. Third legal consequence is an obligation to release a gained benefit in case the officer would be gaining any benefit based on his inappropriate action and not acting with due care. A gained benefit under Czech law can be any movable thing, like a gift from, for example, a competitor under a tender which would be organized by the company where the official is acting for, or immovable property, or immaterial right, or an asset. So anything which would be acquired by the official as a benefit must be released due to the liability. So that's the release of the gained benefit as a legal consequence. Next option is a removal of an official by court. So the court under Czech law and in the Czech Republic can remove an official from a statutory body. So this is only applicable to statutory bodies members for up to 3 years in case the official repeatedly or seriously breached his or her duties or contributed to a bankruptcy of a corporation over the last 3 years prior to the court proceeding. Such a claim to the court can be submitted by anyone who is seriously concerned about the things which happened by behavior of such a official. But the decision-making body is not the general meeting, but it is occurred. And it takes time. Such a court decision is, because such a court process is never easy, but yes, the court can decide to remove the official from the statutory body positions. And the last one is the recall of an official by highest body, typically by a general meeting of a corporation, which is stipulated and implemented under Czech law for any reason, anytime, even there is no breach of the acting with due care by an official. So he can be removed by owners, which means by the general meeting as the highest body of the company. And in practice, it typically happens if the company, if the owners has a suspicion or even proof or even cause damages by the official, and there is a loss of the confidence. So they remove such a member of the body and he ends up in his position immediately or at the day which is mentioned in such a recall. We have to say that if the owners of the company are not sure and are hesitating whether the corporate official would be acting with due care and whether they trust him or her, it's really worth to recall such a person from the position, because then you deeply decrease the risk of potential damages which could be caused by the official. And my last point is, in whole situation of acting with due care, what to do in practice, in a business practice, to cover this issue, because the damages which can be caused by a inappropriate acting by a corporate official can be really high, much higher than the assets and property which the official owns as a guarantee for recovering the damages. So what's a good practical point, and it happens a lot in the practice, even from my own experience, is that the companies enter so-called directors and officials insurance policy, and it covers any monetary damages, settlements and costs, even legal costs, which would be resulting from claims made by the company or by any third party, including creditors, against such officials who were in their function, for breaching any fiduciary duties, shareholders' legal actions against officials, reporting errors made, for example, in financial documents, especially in companies who are publicly tradable at the stock exchanges, claims of non-compliance with industry regulations or laws. So for any kind of negligence or negligence actions, while we have to say that these D&O insurance do exclude, of course, any action which would be made under fraudulent behavior or intentional criminal acts or illegal actions. So yes, in practice, there is this solution which is, as far as I know, taken, this D&O insurance, by every larger company to remedy any risks arising from negligent mistakes made by officials. And that's all from me. I'm happy to answer any question you would have, or later at the break. Have you heard me?
Yes, of course. We heard all your report, and we have mentioned earlier that the questions and discussion will be after the first 5 reports before the pause. So now I would like to remind and to repeat that we have one by one first 5 reports, and after that a common discussion of between all participants. Thank you once more. Dr. Tolstoy,
Thank you
thank
very
you
much.
for your report. And I would like to invite for the next speech, for the next report, Professor Majdanek, who joined us. And Professor Majdanek, the floor is yours. Please.
Thank you, Alexander. Thank you very much, dear colleagues, for this opportunity to take part in this online discussion. My topic is social function of corporate law in terms of Europeanization. The problems, the topic of the social function is current subject matter of the corporate law. And challenges of the global economy lead to a tendency to strengthen the legal effect of corporate law in relation to the cycle of third-party stakeholders and the need to exercise it with the due regard for private and public interests. And when we talk about the real practice of the social function in this field, in the field of corporate law, I have to say that the most significant results in this field we have in the French law. Under the civil code of French civil code, each French company must now be managed in accordance with its corporate interests and taken into account the social and environmental issues arising from its activities. According to the French Civil Code, have the provisions, Article 1833, which defines a company as formed in the common interests of the shareholders. Now, this civil code provides that company has this provision has a second paragraph stating that corporations must be managed in their own corporate interests by taking into consideration the social and environmental issues related to their operations. Another article, 85 of the French Civil Code, has been amended to allow corporations to specify in their bylaws a fundamental purpose for the corporate operations. This means that companies are encouraged to incorporate social objectives to their corporate purpose as part of their bylaws. It's very important that these amendments to the French Civil Code and Commercial Code are there as a result of the so-called the Pact Statute. It's like a soft law project which was prepared by a working group of the scientists, and they prepared such recommendations which were resulted in these amendments to the Civil Code of French and Civil Code, Commercial Code of France. The Statute Pact provides that non-compliance with these new obligations doesn't result in the invalidation of the company. The aim is to protect companies from the most adverse consequences of breaching what may appear to be a weak obligation. And finally, I'd like to highlight a bit another issue related to the corporate social responsibility. Important part of corporate law, social function, are tools of the corporate social responsibility, including mandatory corporate social responsibility due diligence, mandatory corporate philanthropy, mandatory governance structure, etc. In this context, the European legal doctrine of corporate law is characterized by the emergence of the understanding of such social liability as a management process which inspires process-oriented laws. This regulatory approach is to require companies to identify social and environmental risks associated with its business operation and establish and execute reasonable plans to prevent harm resulting from the identified risks. And France's duty of vigilance law, adopted in 2017, spearheads this approach. As pointed out some others, French law requires large French companies to develop, disclose and implement a vigilance plan in order to identify risks and prevent severe human rights violations and environmental damage resulting directly or indirectly from the operations of the company. Its subsidiaries or its subcontractors with whom it has an established relationships. Importantly, those harmed by the company's failure to establish or implement a plan may launch civil action and seek damages for corporate negligence. Current Ukrainian legislation, including civil code and special laws, haven't any systematic provisions regarding these type of social liabilities like in the French law. Ukrainian law provides for certain provisions on the social function of property rights, which is reflected in the provisions of the Constitution of Ukraine and the Civil Code of Ukraine on the compulsory alienation of private property for reasons of social necessity, and but not for the purpose of the corporate law. The provisions of the Constitution of Ukraine stipulate that property shall be obligatory. The Civil Code of Ukraine doesn't provide for the obligation of an entrepreneurial company to have a legitimate corporate purpose to be established in the common interests of its members, to manage in the company's own corporate interests, taking into account social and environmental issues related to the activities. In the context of Europeanization of the Ukrainian law, it is necessary to clarify, to define in the civil code and maybe in special laws, maybe on business association, on joint stock companies, etc., the provisions on the social function of corporate law, according to which corporate law obliges to or have to act with regard for the public interest. Therefore, maybe it could be good, it could be reasonable to prepare amendments to the Civil Code of Ukraine with the following provisions. For example, in the Article 113, social function of corporate law. Maybe previously as an analog according to the French law. Summarizing my speech, I'd like to say that this problem, this approach is a real relevant problem for the Ukrainian corporate law, because we have previously the approach which is grounded, which is based on the obligations of the Ukrainian companies to make reports, to inform about sometimes types public informations, but not more. Therefore, I think it would be good to more deeply understand and make research. I mean, the practice, French, first of all, French practice of this, of the social function of corporate law. Thank you very much for your attention. Alexander?
Thank you, Professor Maidane. Thank you for your report. Yes, it's really actual for Ukrainian legislation, and is really an actual discussion which legal system to take into account, and also in context of social corporate responsibility and French, American, or British experience, or German. So that's why thank you for your speech and for the topic of your report. And I would like to invite for the next report our colleague from Poland, Dr. Żaba. Dr. Żaba is a permanent participant of our conference since 2014. Every year, almost every year, Dr. Żaba is always take part and maintains our conference, and thank you for this, and I invite you to your speech. The floor is yours, please.
Thank you very much, Alexander. At the beginning, I have to thank you for your invitation in inviting me to this event. It is always a great pleasure to be here, but unfortunately, it's such a pity that I have to take part in this conference remotely. So it is much better to participate in person, of course. I have been asked by Professor Kovalyshin to present my paper in English, not in Ukrainian. So I will give a little speech in English. I would like to say a couple of things about creditor protection in case of cross-border division of companies in Poland, but the situation I want to describe in my article, in my speech, in my paper, is the case when company being divided is a Polish company. This is the main. This is the center of my speech. So I've prepared a presentation. So I would like to share this presentation via the Zoom, and I hope it will show. Unfortunately, I have the place I am at this moment have a poor internet connection, so I will share this presentation, and I'm pretty sure that I have to switch off my camera. So probably it doesn't matter, but the audio will be launched. So, anyways, I will try to share this, and I have to. Do you see anything?
Yes, everything is okay. We can see your presentation and your slides. Mm-hmm.
Okay, so this one, no, not this one. Sorry. Here's so. Just wait a second because there's a problem. I see. Just wait a second. I'm sorry for that, but maybe in this way. Oh, maybe here. It will be better. Do you see my desktop? Yes. Okay.
Yes,
So
we may see.
thank you very much. So as I said, I would like to present a couple of things about protection cross-border divisions of companies under Polish law. Of course, there is a huge amendment. There was a huge amendment of the Polish Commercial Companies Code because Poland was, I will say, forced to make an amendment of provision of companies code, commercial companies code, because of implementation of Directive 21 of 27th November 2019. And one of the salient issues in the context of the divisions, because this directive was linked to the transformation of companies. And one of the salient issues in this context, I mean, of the division process, of transformation process, is the matter of creditors' protection. So, of course, both national and cross-border divisions may carry the risk of violation of rights, of course, but at the level of international level, it might be much worse when company being divided will flow assets to the company in other countries. Reasons for protection, of course, is the transfer of assets, as I said, and the change of personal statute. As I said, the main situation I want to describe was the situation when company being divided is Polish. So, the newly formed or existing companies will be in other countries, member states, and how will it look? The problem of this change of personal statute of this company, I will say, this company which will be divided, is as well prohibition of invalidating a cross-border division which was registered in the court register. The Polish legislator adapt the temporal scope based, of course, on the directive level of the minimum scope of protection of creditors' interests, and this scope is linked with ensuring an appropriate system for protecting the interest of creditors whose claims precede the disclosure of the cross-border division plan. The draft terms, I will use this term interchangeably. Plan or draft terms, it is the same in this part, and this claims have not become due at the time of such disclosure, and as a consequence, cross-border divisions, I said, the assets, rights, obligations of the company being divided are transferred to the company newly formed, and in the light of this fact, the company which company will be the debtor of the previous creditor is depend on arrangements specified in the draft terms in this division plan, in this division plan of the cross-border division. Of course, the draft terms of cross-border division shall determine in detail which obligation would be accrued to each company after performing a cross-border division. But of course, this is one of the reasons that this protection should be made for creditors. Talking about instruments of protection, creditor protection, we can say that we have the legal protection on two grounds, on two surfaces, institutional and individual. The institutional ground of this creditor rights protection is based on objective rights and has only preventive character. And the second one, in the sequel, I mean this individual, it will not directly create a possibility to protect subjective rights of creditor individually. This institutional protection does not require any action of creditor in order to be realized, because it appertains ex lege and creates some, I will say, frames, circumstances for bringing claims by creditors against company in the future. And however, the individual ground of creditor rights protection is founded on subjective rights, which has the creditor and appertains him directly for demanding a security or a satisfaction of his claims against company being divided. So talking about these institutions, in the commercial, in Polish commercial companies code, we can say that we have on the surface, on the ground of institutional protection, three instruments: obligation to disclose the draft terms, this plan of division, scrutiny, the legality of cross-border division by auditor, inspection of compliance with national law, and issuance of a certificate of compliance with Polish law of cross-border division in the scope of the procedure governed by this law. On the individual protection ground, individual protection instruments are right to demand the security of claims, as I said, right to obtain the satisfaction of claims, and we can say that we have other forms originating from law of obligations, not from directly, not from the commercial companies code. I mean, here, I think here about Actia Pauliana, for instance. Anyways, as I said, institutional protection is based on objective rights, objective law. Personal protection is based on subjective law. Personal protection, individual protection requires action by the creditor. Institutional protection does not require any action by creditor. And talking about that, in Poland, we have the instrument, which is information obligation regarding the disclosure of cross-border division plan, and this mechanism of institutional protection is under the Polish provision created in this way that the company being divided is obliged to disclose and made publicly available in the national register this draft terms of cross-border division, as well as notice informing that creditors may submit to the company, as you can see, that creditors may submit to the company, of course, the comments concerning the draft terms of the cross-border divisions, that there is a temporal frames, of course, at the latest 5 working days before the date of the general meeting, they have to do this action. Legislator has stipulated that these documents shall be disclosed at least 1 month before the date of the general meeting, and the regulation, Polish regulation, institutes the special possibility to exempt a company being divided from this disclosure if company makes those documents available on its website free of charge to the public at least 1 month before the date fixed for the general meeting. The next instrument is, I will say, inspection of compliance with national law and issuance of a certificate of compliance with Polish law of cross-border division, and audit of the transformation plan by the auditor. The first instrument is linked with competences, I will say, of the registration court, because registration court shall issue to the company being divided a certificate of compliance of the cross-border division with the Polish law with respect to the procedure governed by that law, that this procedure was made and was made with regard to Polish law, and the registration court shall enter an annotation on the cross-border division in the register unless this court finds that the cross-border division serves to abuse, infringe, or circumvent the law. The next instrument I want to describe is instrument which is based on the individual scope, individual ground, I will say. And this instrument is the right to demand the security of claims. This instrument is performing. This instrument performed the possibility to issue by to demand security for claims that have not become due at the time of disclosure or disclosure of the cross-border division plan, if they prove that the satisfaction of their claims is threatened by the cross-border divisions. We have the formal premises of using this right. Creditors have 1 month from the disclosure or release of the cross-border division plan to report to go with a claim to demand the security of claims, and any dispute between a creditor and the company regarding this instrument, regarding granting of security, is resolved by the court having jurisdiction over the company's registered office, a commercial court in Polish case, at the request of the creditor, and application must be submitted within 3 months from the date of disclosure or announcement of the cross-border division plan, cross-border draft terms. The last one instrument is right to demand the security of claims. This last instrument, however, this last instrument is based on the is based and I would say linked to the previous mentioned institution of the security of the claims, because this right to obtain the satisfaction of claims shall be shaped with regard to the fact of moment of rising the debt of this company, and the possibility to, I will say, benefit this right should originally embrace these claims that became enforceable by the date of disclosure of the draft terms of cross-border division. However, the fact whether the creditors which actually have those claims will benefit by this right depends only on them, because this is the example of the individual instrument of protecting creditors' rights. This provision, I will say this Article 580 with Index 14, this provision provides that the claim of the creditor of the company being divided will not be satisfied by the company to which the liability is allocated. The other company is newly formed, and in the case of partial division, the company being divided shall be jointly and severally liable with the company to which the liability is allocated for the obligation. Moreover, each company participating in the cross-border division shall be, as we said, shall be jointly severally liable only to the value of the net assets allocated to that company at the day on which the division takes effect. So these two instruments, I will say, right to obtain the satisfaction of claims and right to demand the security of claims, are linked with the action of creditor. This three I've mentioned before are based on the institutional ground and are don't require any action of creditor. Anyways, I hopefully I did not talk your ear off, and I would like to thank you for your attention, and as I hope that I did not talk your ear off, and it was a couple of things interesting in this newly adapted regulation in Polish law. Thank you very much.
Thank you, Dr. Mateusz. Thank you for your report. And cross-border divisions, they are really a common problematic for Poland, for Ukraine, Czech Republic, and Uzbekistan. That's why, in any case, these your ideas and your analytics will be useful for the development of our Ukrainian legal science, and as well as legal science of Czech Republic and Uzbekistan. Thank you once more. And I would like to invite for the next report our colleague from National Academy of Legal Sciences, Dr. Kochen, with his report. And I forgot to say that at the same time he works as an assistant consultant by Constitutional Court of Ukraine. Dr. Volodymyr, the floor is yours, please.
Thank you very much for invitation and for making this report during this conference. I would like to share my presentation. I try to do it. So here it is. I hope you all see my presentation. So I would like to talk about corporate governance, the giant and leather panda in the legal entities institute. So it's a little bit companion and it's comparative research according to some legal issues and also some biological instruments which will help us to understand some problems in our corporate and company law. First of all, I would like to say that the main research ideas which we can hear during 22 conferences in Ivano-Frankivsk. They are concerning nearly to commercial law and company law, but now I hope that even for 10 past years or even more, we also can hear reports according to corporate governance, according to association and foundation law, which also is very necessary for our future research, especially during improving our legislation in Ukraine. Also, there are some new cases, even in Constitutional Court of Ukraine, which concerning to problems with legal regulations in association law. For instance, there are several cases with corporative acts or legal acts which appear in advocacy companies and in advocacy associations. So it's also only one of the problem which now is in Ukraine legislation. But all in all, there are a lot of big associations like UAFA, which also has corporate governance with special bodies, with special arbitration even, and with special norms which this company in broad meaning use. So, in our Civil Code of Ukraine, we have a new norm which norms the understanding of corporate rights. And now this article is also concerning to rights of participants of legal entities or corporate rights, which are a set of powers that belong to a person or participant, founder, shareholder, or share of a legal entity in accordance with the law and companies charter. One of these problems that we tried to understand and to connect together understanding of company law in entrepreneurial and non-entrepreneurial spheres. So it's looked like Alexander Milne novels with Winnie the Pooh, which was translated into Ukrainian and in Russian language also, Winnie Pooh and all, because they tried to collect all the stories with this bear. We will talk about bears today a little bit more. So, and there was a problem that corporate rights were used only for corporations. Then we thought that corporate rights also can be used for non-entrepreneurial companies or non-entrepreneurial societies, but all in all, the new legislation, which you can see on your screen, they made a final point in this problem, and corporate rights contains features that could be applied to all organizations, but
Excuse me, Dr. Vladimir, excuse me. We still see the first slide, the first official slide. Should it in such
yes,
way
it should be
be?
a second one, and I think third one even.
No, I and Natalia Filatova have
Sorry,
mentioned
just
that still the first one is on the board, and yes, now the slides move.
okay. I will do this in another manner, maybe in such way. Is it good?
Yes,
Yes.
perfect. Now
Oh,
perfect.
okay.
Mhm.
Let's do such way. Okay. So sorry for this. After that, we should talk about the main problem, scientific problem as Professor Zuzulak said, we sometimes even investigate problems in our company law and corporate law, because sometimes the nature of these relations are quite difficult to understand, quite difficult to make it in one order. Sure, now we are talking about public interests, social interests, even ecological and so on. So in corporate law, sometimes it's very complicated to get all these spheres and all these relations in one code, in one act. So sometimes it's very difficult to understand. So I won't tell you much about this, about understanding of nature. I think that you will read it in my article, and also you should know about this. But I'd like to admit that during the understanding of this problem, we also should look back into our history and should research the roots of this problem. It's very interesting that understanding of corporation formed in religion, and the understanding that corporation is just a body of Christ, and all members in particular also part of this body, of this organization, and now it's transformed into commercial ideas and commercial interests, and now we see the changes from non-entrepreneurial to pure commercial interests and pure commercial formation of this company law. So I think that such a narrow understanding of entrepreneurial company is also one of the way to understand the nature of corporate law. But we can see that problems which arise in different associations, for instance, association of flat owners, or now we will find some problems in charity law, especially transnational charity relations, which we can see in Ukrainian practice, will also be useful for understanding the broad understanding of corporation. All in all, the main concept of corporate relations and corporate rights are concerning to civil rights concepts. So the right of own actions, the right of actions on others, and the right to defense. All in all, this concept we can see in relations between person, all in all, in general understanding, when we can divide powers to govern legal entities, right, to other actions, we should understand that it sometimes can be used as administrative law in some way, but we understand that it's a private law nature, and these powers are not powers like public authority. Also, scope of corporate rights, rights to own actions. It's also not only connected with property rights as pure corporate rights in a business company, and also the right to realize subjective right interests that preceded participation in legal entity. So subjective civil rights will arise. So it's not only money, it's not only profit, but also sometimes we can say about some civil rights which a person receive during such realization of its subjective right, and also some benefits which have not property nature. So when we transfer our idea to the corporate governance and self-control ideas, its main features of such autonomy, which is in private entity. possibility of independent decision-making regarding to liquidation and reorganization, the absence of public servants in administration who manage the organization by executive authority, and absence of external influence on the formation of executive bodies of the entity. Such understanding and such features are very useful when Ukrainian legislator try to build, to make new forms of public-private organizations or public organizations with corporative governance, some independent organizations, and we should understand that sometimes models when public authority, government, for example, plays a role of a corporate body is not useful, and it's not economical useful this role of corporate body. So when we speak about conclusions and making further research in this sphere, I should admit that sometimes we're trying to find some common features, just looking for similar ideas and similar features of organs and animals, for instance, which are not so related to each other. When we try to compare to these organisms, big panda and small or lesser panda, they are not relatives like relations of corporate relations and membership. All in all, the nature of these relations more quite similar than these two pandas. It's not only name of relations, but also the nature of these relations. So for future purpose of legal certainty and distinguish, there should be between corporate relations in entrepreneurial societies and membership relations in entrepreneurial societies. But the corporate governance is similar phenomena which can be used in both of them. So it's also a homological phenomena when organizational part of bodies changes for its purpose. Wing, leg, arm, and so on. So we can use corporate law in non-commercial sphere, and also we can use some ideas from non-commercial law in commercial sphere. So such ideas can be useful for both of them. Also, when we would like to conclude, I should say that we shouldn't forget some another ideas which exist in public law and private law. For example, when we speak about bears, we can forget about koalas, which sometimes also used to name as a bear. For instance, Latin name of this animal is Phastolactos. From Greek, its name as I am a big bear. So sometimes we should understand that relations in different organizations can have a different nature. Sometimes they can look like each other, but we should understand that roots of the problems and roots of the regulation of these relations can be different, and they should have their own understanding and scientific researches. Thank you for your attention.
Thank you very much for your report. Thank you once more. And the next report should be presented by Dr. Losichkova. But she has written just a moment before that she will connect a little bit later. So I would like to ask Dr. Holmerzaev, could you continue our reports? Yes, there is a possibility.
Hello,
fine.
Yes, I'm
Hello.
ready.
Hello.
Okay.
So the floor is yours. Please.
Good afternoon, dear guests and colleagues. It's an honor to be here and to share with my findings on Uzbek limited liability companies law in the lens of the legal transplants. Please let me share my presentation. Can you all see my presentation?
Yes, we may see. Yes, everything is okay. The slides move.
Thank you so much. So thank you so much to organizers of this conference for inviting and have such opportunity to share my findings. And today I want to share my research on how limited liability companies, which were originally German limited liability companies concept, adapting to the legal environment of the Uzbekistan. I hope it will be interesting and can contribute to make some conclusions on the harmonizations of the legal system of Ukraine to European legal system. So my research refers to the legal transfers, and my main findings related to the legal transfers are key mechanism of legal change. As we know from the history and from the prehistoric time, human populations learned from each other. They didn't live, most of them, they didn't live in isolation. They had and today we have also tight contacts with the other populations, and we always learned from more successful societies in some areas of the social life. So legal transfers are a major factor of accumulating knowledge. There are no any legal systems which are relied on the experience of one population. They always relied on the experience of the all societies in this region. And tacit knowledge in the framework of my research refers to our knowledge about some concepts of the legal concepts or legal rules, and context refers to the interdependence and system complexity. So what is Uzbek LLC law? Limited liability companies are quite popular in Uzbekistan, and they consist about 72% of all business organizations, and main legal foundation of this limited liability companies law is a Limited and Non-Limited Liabilities Companies Act of 2001. This limited liability concept, I think it's same with all CIS countries, including Ukraine. It's transfer from German GmbH, and main features are independent legal entity, limited liability, transferable shares, and centralized the other corporations. And I want to emphasize that around the world, all corporations have so many familiarities, which highlights their same origin from European legal traditions. And today, the adoption of these Western or European legal concepts and other cultural traits are struggling with context in other societies. And our empirical study demonstrates judicial disputes, corporate disputes in Uzbekistan involving the limited liability companies. So we have studied some more than 160 judicial disputes in the Republic of Uzbekistan during the 2023. And main part of 50% of these disputes consist the invalidation of general meeting decisions. And about 18% expulsion of the member from the, and about 20% challenging transactions, and about 20% other types of the corporate disputes. And what this empirical study demonstrate, and how we can understand this adaptation or the struggling to be adapted in new environment, because it's very important. And every society has their own cosmology, their own system, their own system complexity, and to learn or copy legal concepts from other societies doesn't mean that these concepts will work as in original society. It's a very complex question which involves more interdisciplinary approach. And today we are going to account this issue in the lens of legal studies, legal theories like legal transplants, which was initially articulated by Dr. Alan Watson, and the anthropology, social anthropology. So invalidation of general meeting decisions, which consists more than 50% of all corporate disputes in Uzbekistan, such high number of disputes in this category highlights the problems in decision-making process. And expulsion of member of LLC, such kind of the disputes are rare in European legal traditions. It's also very hallmark of the such struggle in new environment. And challenging transactions, including the major transactions or transactions with the related party, also suggests transparency and trust between shareholders and management may be lacking. So main quantitative results here, and most of our conclusions, of course, they are tentative and they need to be validated. It's still ongoing research. So first qualitative finding is post facto disputes. So almost 90% of the disputes are post facto. So claim must be filed within the 2 months after claimant becomes aware of this resolution of a general meeting, but about 90% of the claims were filed later. It's not later like 2 months, 3 months, but decades. Sometimes it takes decades, which means there are so many problems with the perceiving this LLC concept and formal procedures of the corporate governance. Second thing is lack of proper documentation. In many cases, disputes arise because of the lack of proper documentation. Then informal agreements. The huge amount of the informal agreements also highlights the legal cultural context of the society, which is quite different from the Western or modern societies. According to the anthropology, conditionally, we can distinguish the modern societies, which we can call also Western, and traditional societies, like they lived during the thousands of years according to their own legal traditions. And violation of information rights, which exist in every case, and reconsideration after consequences, which is related to the post facto disputes. So in many cases, would say it's about most of the cases, claimant reconsidered of our empirical study. For example, in the first case, we can see that claimant sought to invalidate general meeting decisions in 2014. It's about 10 years later. It's about 10 years later. It's something very important, very notable, because in this case, claimant says they had some informal agreements, so I mean oral agreements, and they didn't, they couldn't reach this deal, and then he claimed it to the court. So it means so second case, plaintiff and 6 witnesses claim that general meeting was not held. It's just they just signed it, and they just officially signed the document, but in the real world they didn't come to the company, and they didn't organize the general meeting at all. And in a notable case, near-term LLC case also highlights some kinds of very strange registration system in Uzbek LLC law. In Uzbek LLC law, when you are going to register the charter, you should draft a new edition of the charter, not the part which you are going to change, you are going to amend. It means who is going to draft this charter can change the other parts of the charter which has not been discussed in general meeting. So did one of the defendants in case, and shareholder unilaterally changed it in his own interests. The other members of the LLC were aware about this later, and they anyway could claim and could deem this new amendments void, but it took about a year. And lack of the share transfer registration system. During our empirical study, we found that in Uzbekistan, there is no any concept of share transfer registration. Under the state registration, Uzbek legal doctrine assumes the registration of the charter, but not the transfer of share. For example, if A buys B's share, but cannot become the shareholder because share transfers are not registered in Uzbekistan commercial register, the shares only can be recognized after the charter amendment. And of course, you cannot approve the charter without the other members who didn't, for example, sell their shares. So if they against the approval of the new edition of charter, you cannot be shareholder. Of course, which is very illogical, but still it exists in Uzbek legal system, which highlights the complexity of this legal learning or legal transfer system, which I call the tacit knowledge. Tacit knowledge refers to the knowledge of professionals which cannot be found in the, for example, in legal acts or anywhere in written form, but they can estimate in their own practice. So it's difficult. It was difficult to the legislators and Uzbek legal scholars to define how this registration system works. So they couldn't copy or learn this process. So second, more fundamental problem of legal transfer of LLCs in Uzbekistan is directors' status. So in Uzbek law, and according to my information, even in Russian law, I hope in other legal systems it doesn't exist. Director perceived as employee. So if dismiss the director, this dispute can be considered in the civil courts as a labor or employment dispute, which is totally different from the Western societies, because it's clear, it's very basic in, for example, in Germany, which is origin of the limited liability structure of Uzbekistan. The director is not employee because it's not the less powerful. Director is most powerful actor in the corporate disputes and corporate practice. So we assume that this structure reflects a remnant of social legal traditions, because according to the labor code of Uzbekistan, every company's director is employee. So how we can theorize these findings? First, legal transparent theory initiated by the Watson. So empirical findings suggest that misalignment between borrowed or copied legal concepts and local corporate culture. So it's always different. It's always we should adapt. And Uzbek LLC law struggles to integrate fully into its own cultural institutional framework, where corporate governance is strongly influenced by informal social structures, which is evident in almost 90% of the cases where informal social relationships exist. The lack of independent shared transfer registration system also illustrates the incomplete adaptation of this legal transfer or legal transplant. Close-knit social relationships play a significant role, and shareholders often have their personal, family, or the friendship business relationships, which can be beyond this corporate structure, which is also important. We should take into account that some corporate social relationships can be overlapped by other social structures and social systems like friendship, family, kinship, and other social ties, which can be more powerful rather than formal corporate structures. And personalized nature of business interactions in Uzbekistan, where oral agreements, personal trust may often substitute formal documentation. So it's a collectivist culture, which is main concept of the anthropology. So we are more collectivist rather than Western societies, which are more individualist, and it also reflects to the legal transfers. Culture or individualist culture and the traditional more traditional culture also align with our empirical findings. So it's more complex rather than we think. So we can say that if we learn or copy the legal traits from the other societies, they can work easily, but we cannot reinvent the other rules, which we should change our own environment also, which cultural appropriation theory says that the appropriation will lead to the change of our context, not only the legal trait which we learned from, for example, West, but our own context also. So we can recommend to develop a shared transfer registration system, clarifying the role of directors, promoting transparency and documentation, which now in the process of ongoing process of drafting new LLC Act in Uzbekistan, and we hope this empirical findings will be considered. Thank you for attention. Thank you for your attention. It's our endeavors to find some patterns of the legal transfers cultural context.
Thank you for your report. Thank you for your report concerning limited liability companies. As it was mentioned at the beginning of the conference, now we have a possibility to have a short discussion to ask our partner colleagues concerning their reports. I invite all and encourage all the participants to give the questions to other participants. Please. Dr. Zuzulak, Professor Zuzulak, please.
Thank you, Alexander. I have listened with a close attention all reports of participants, and it was really so relevant topics. And our colleague from dedicated their report to the legal liability of police officers in corporate relations. And I would like to know about where are the main provisions which regulate questions of civil and corporate liability of corporate officials according to legislation in the field of corporate law of Czech Republic. Thank you.
Dr. Tloustova, as I understand, that was the question to Dr. Tloustova, yes?
Yes.
Dr. Paula, do you hear us? Maybe some disconnection with her dynamics, I don't know. Dr. Paula? Maybe
she doesn't hear us.
She doesn't hear us. Maybe some technical problem just for a moment, just for a while. So in such a case, I would like to ask and to have some remark concerning the report of Dr. Holmirzaev. Really interesting report concerning limited liability companies, and you have mentioned about director dismissal, that according to your country, your state practice, the courts very often apply labor code, and that is in contradiction with West tradition, where director is something more than just an employee. In Ukraine, the situation is in the middle of this way. From one side, in Ukraine, there are such a court practice that director is announced like an employee and they apply labor code, but at the same time these disputes concerning director and director's dismissal are also in practice code of commercial codes. The main reason, the main issue, what is the ground of the dispute, and of this, because of this, depends is it commercial code or labor code. But I agree with you totally that civil practice can't to explain and to resolve these disputes so perfect like commercial court practice, and yes, it would be better if we take into account this Western approach for labor disputes. So thank you for that. And maybe some other questions, please. Dr. Filatova-Belarus, please.
Thank you so much. I have a question to Volodymyr Kochin, if I may. Thank you for your yes. Thank you for your report. It was really interesting. So I just wanted to clarify, we recently had a new article in our civil code. This was article 96.1, and it introduces a new concept of corporate rights. And it says that corporate rights are rights that belong to the participants, to the, like, let's say, shareholders of legal entities, right? So this is a broad concept, in fact. And from this concept, we can make a conclusion that corporate relationships, they can be originated in any kind of legal entity where there are corporate rights, and corporate rights are defined, as I have already mentioned, very broadly. So what do you think? How should we interpret the term corporate relationships, considering this new concept of corporate rights, which was introduced in our civil code recently? Thank you.
Thank you for your question. I think that I should admit it will be useful for our foreign colleagues also, because the main problem of this amendment in civil code is using maybe not so good legal technique to describe and to norm these relations. Because when we start to read Article 96.1, we understand broad concept of corporate relations, but further we see special subjects like shareholders, shares, and so on. Further, we also see the main root of these relations, which is property on share, property on some other civil object, but we don't know exactly which civil object can be used in these relations. So the practical aspect of this we can find in economic procedure code when we speak about corporate disputes and these cases in court. First of all, maybe 5 years ago, maybe later, we was speaking about problems of these issues when we saw amendments in this procedure codes, when amendment to a special article where we could find corporate disputes and other concerning with relations in legal entity, and we thought that only corporate disputes, but now we can also find in courts disputes which concerns to associations of flat owners, also with some public associations. So it's also kind of disputes, but they are not corporate. I think that it's a misunderstanding when such conflicts we can name corporate. I think it's also membership disputes, but not corporate on one way. And another one point is that we can find corporate governance in different organizations, but with similar features, with similar nature. For instance, the process of voting, the process of formation of corporate bodies such as council, executive director, and so on. The main point that we can find in amendments of civil code that our parliament tried to form this norm in a special way, but I think that they a little bit changed the idea of forming legal techniques. First of all, they should note about subjects of these relations, object of this relation, and then they should wrote the nature of corporate relations. I hope I am finished.
Yes, thank you. But this issue revealed itself very, I should say, unexpectedly. For example, when my colleagues applied for, this competition to become the judge, yes, there was a point where they needed to write down whether they have corporate rights and whether they are in corporate relationships. And some of them, of course, were not the shareholders in some economic entities or something like that, business entities, but they were members of NGOs. And so they questioned themselves, should they say that they have these corporate rights, corporate relationships? Of course, this is a kind of absurd. It doesn't work this way. This is not what they wanted to know from the candidates.
Yeah, sure. Another part of this problem that some participation in public associations and in charity funds, they have no salaries during work in such organizations, and also they would like our public authorities. I mean, they would like to find some corruption schemes or some criminal issues of this process, but I think it's not a problem for civil or corporate law, but also it's a problem for criminal or public law in such way. Yes.
Okay, thank you.
Professor Zulek, you have some remark or question?
Yes, I have listened your discussion about concept of corporate rights in the Article 96.1 of the Civil Code, and I agree that this concept need to be improved because it's not. It seems not good, and our lawmakers and scientists who work in the field of corporate law, we together must work on this, yes, and to make everything to change this provision, yes, and to define in this article of Civil Code correct concept of corporate rights. I would like to mention that Professor Inna Valentina Spasiba-Fatiyeva, famous Ukrainian scientist in the field of corporate law, also said about this problem, and a lot of scientists, Ukrainian scientists who works in the field of corporate law, try to work on this issue, and many articles, scientific monograph from during these years, yes, also tries to make correct approach to understanding corporate rights. Yes, and also I would like to mention, I don't see Professor Majdanek, yes, but I also agree that we must also work to updating civil code and other legislation in the field of corporate law to make strengthen role of social function in corporate liability. Yes, and all these questions and about legal nature of legal entities and about interests in different types of legal entities are really relevant for Ukrainian legislation, especially at the process of adaptation of our legislation to European corporate legislation. Thank you so much. Thank you.
Thank you very much, Professor Zuliak. And now Dr. Kochin, please.
Yes, thank you. I would like just a small idea of this problem. One point also is that our public authorities try to find corporate law where there is no corporate law. For instance, some public authorities which has a council or some function bodies like corporate government, they try to make it like in limited liability company or something like that. For instance, we even now have problem about liquidation of Supreme Court of Ukraine, the previous one, Supreme Court of Ukraine, not this one, where judges of Supreme Court voted not for liquidation of the organization like in corporate way, but it's not corporate relations at all, and it's not way to change the regulation of this institution. Also, sometimes public bodies have double nature of corporate governance when they vote for organizational issues in corporate way, and for the power issues on a special way of voting. For instance, Constitutional Court of Ukraine judges voted for decision or some other procedure elements like judges, and they need quorum for their voting. And for organizational issues like property of court, like changing of structure of court, like making you provisions during organizational process, they vote like in corporate organization, and they don't use the public authority in this way. So we should not looking for a corporate law in not corporate relation, and even not in private entities. Thank you.
Thank you, Dr. Konchin. Maybe any questions? Other questions? If there are no questions, just a moment. We have a shot in chat. So, as I understand, Professor Zuliak, the answer for your question is in chat. So everybody may be acquainted with the answer in chat. Thank you, Dr. Pavlan, for your answer. And if there are no other questions, I would like to announce a short pause, near 15 minutes. I think 15 minutes is sufficient, and I encourage all our participants to connect, not to disconnect, or if at this moment you are disconnected, to connect once more after this short pause. So at this moment we have 2:05. At 14:20, we prolong our second part of our conference. I repeat, at 14:20, according to East European time, 14:20. See you soon.
See you soon.
Dear participants, we continue our international conference in the framework of International Visegrad Fund grant on company law. And the second part of our conference starts with the report of Dr. Filatov Belos. Please, Dr. Natalia, the floor is yours.
Okay, thank you. Thank you so much. I'm really happy to be present today here. Thank you so much for the invitation. I will try my best to meet the the time limitations of my speech, but I always fail, so I don't know how it goes, but I will try my best. Now let's check my presentation, whether the slides switch or not. So now I switch them. Do they switch?
Yes,
Okay.
everything is okay.
Perfect.
The slides move, switch.
Okay, thank you. So the topic of my report will be once again about the limitation of directors' powers and the validity of transactions entered by a legal entity. So in fact, this topic is not so much innovative. This is a kind of a classical problem in company law. And I know this, but still practice shows that there are a lot of disputable issues in this regard, although a lot of provisions have been introduced long ago, both in European secondary legislation and in Ukrainian legislation as well. So I'm going to compare the provisions of European legislation and Ukrainian legislation and show the problems which we face in Ukraine now with this issue. And I also invite you for the discussion because I think that republics which were under Soviet regime and also other republics which were under socialistic regime, if we look at this broader, they may also face the same problems as we do. So let's start with the general rule, which stems from the first European directive and was introduced initially in 1968. Now this provision can be seen in the directive 2017, which number is 1132. So this is the kind of new directive of the European Union. So the first provision of this directive, considering the limitation of powers of directors and how these limitations influence on the transactions, this provision sounds as the following. Acts done by the organs of the company shall be binding upon it, even if those acts are not within the objects of the company, unless such acts exceed the powers that the law confers or allows to be conferred on those organs. Also, it is mentioned that member states may provide that the company shall not be bound where such acts are outside the objects of the company if it proves that the third party, meaning that the other party to the transaction, actually to the contract, knew that the act was outside those objects or could not in view of the circumstances have been unaware of it. However, it is also said that disclosure of the statutes shall not of itself be sufficient proof thereof. The next provision says that the limits on the powers of the organs of the company arising under the statutes or from a decision of the competent organs may not be relied on as against third parties, even if they have been disclosed. And the last provision is that if national law provides that authority to represent a company may, in derogation from the legal rules governing the subject, be conferred by the statutes on a single person or on several persons acting jointly, that law may provide that such a provision in the statutes may be relied on as against third parties on condition that it relates to the general power of representation. Meanwhile, the question whether such a provision in the statutes can be relied on as against third parties shall be governed by Article 16 of this directive, but in fact it means that if these provisions were disclosed in the state register. So the latest provision, which is the most extended, in fact means that if the national law says that we can deviate from the general provision that only one director can represent a company and the rest directors cannot, or if it on the opposite allows companies to say that all the directors or some of these directors shall act jointly and only jointly. So this is admissible, but if you do have these deviations in your statute, please disclose them in the state registry, and then you can rely on them, and then you can prove that this or that transaction or this or that contract is void because of the breach of this rule. So now I'm going to analyze the first two provisions basically, but not the third one, because the third one is really a very extended one and it deserves a special attention. Unfortunately, I'm not sure that I will manage to cover it within 15 minutes. So first of all, what I emphasized in these two rules is that if the limitations of powers are provided for by the law, yes, then we can rely on them, and then it may mean that the transaction which was concluded by the director of the company in violation of the law, in violation and beyond its powers, this transaction may be void. So let's analyze this. If the act exceeds the powers that the law confers on the organ. Of course, it is obvious that this is not a surprising thing. There is a general presumption that everybody knows the law. Thus, if everybody knows the law, everybody knows which limitations on the powers of directors this law imposes on directors. In Ukraine, we have several laws which introduce these limitations, and the first one is the law on joint stock companies, which was recently adopted in Ukraine. This is a new iteration of this law. So we have the first provision which limits the powers of directors. This provision sounds significant transactions. What does it mean? If a market value of a subject of a transaction exceeds 10% out of the value of the company's assets, according to the latest annual financial report, a director shall have a supervisory board or general meetings prior consent to enter it. So if we have a transaction like that in a joint stock company, then the director may not enter this transaction without the supervisory boards or general meetings prior consent. And we also have the second limitation, which is transactions involving the conflict of interests. So if, for example, a director of a joint stock company is simultaneously a shareholder in the other company, and these two companies conclude a contract, then the director should disclose to the shareholders or to the board of supervisory board that he or she has conflict of interest in this case. And to enter transactions of this kind, the director shall have a or general meetings prior consent, regardless of the value of this transaction. So any transaction which involves the conflict of interests shall have the prior consent. What follows from this? If this or that rule is violated, if significant transaction or transaction involving the conflict of interests is concluded without the consent, then this transaction does not create any rights and duties for the company, so it is invalid. But if a company gives a subsequent consent, the transaction is valid. This is the general rule. And we also have the law on limited liability companies. And it also introduces much the same concepts, but the difference is in the details. Significant transactions. If a value of a subject of a transaction, which the limited liability company concludes, exceeds 50%, not 10% as joint companies have, but 50% out of the value of the company's assets, a director shall have a general meetings prior consent to enter this contract, enter this transaction. And transactions involving the conflict of interests. Unlike joint stock companies, where the legislator provides the exhaustive rules concerning how to conclude transactions involving the conflict of interest, how the director should disclose his or her conflict of interests. The law on limited liability companies says that it is up to the statute of this company to specify the rules on such a transaction. So most of our limited liability companies do not have these provisions in their statutes. That is why this rule is unworkable. And so it also goes down to the significant transactions in most of the cases. So if a company concludes a significant transaction and the director does not have a general meeting's consent, then there can be some problems because these transactions, they can be invalid unless they are subsequently consented by the company. So in fact, the provisions about significant transactions and about transactions involving the conflict of interests, they are quite original as for our legislation, because I tried to find the analogs in other legislation. And I should say that the results of my comparative research are the following. A lot of countries have the concept of transaction involving conflict of interest. Netherlands have this concept, Great Britain has this concept, and I think that maybe even all the countries all over the Europe have this concept. But when we talk about significant transaction, I mean this first category, this is an uneasy question because I did not find analogs of such a concept in European legislations. I only found it in the legislation of republics which used to be under Soviet regime, like Ukraine used to be. So this is something specific for our countries, for countries which used to be under Soviet regime. And I tried to find the explanation why these countries have this rule. And I found it, I hope so, I found the roots of this concept. So I found the article published in 1996 by three researchers of Harvard University, and their article was called "A Self-Enforcing Model of Corporate Law," and it is really very interesting. So these three researchers took part in 1996 and previously in the development of Russian law on joint stock companies. So they used to live in Moscow and used to help Russians to draft the law on joint stock companies. And they introduced this self-enforcing model. And what they said about this, they said that in Russia particularly, right, after the Soviet Union failed, right, after it broke up, there is a huge problem with market. There is a default and economic crisis, very deep economic crisis. So the corporate law should have some mechanisms which can help to self-enforce corporate law provisions and which can help to protect the interests of shareholders. First of all, of shareholders, and I emphasize on it. So the main conclusion of this article was, in an environment where the judicial system is unreliable, there are almost no corporate law experts and the law itself is not working. The only reliable mechanism to protect shareholders from opportunistic behavior by managers is to introduce clear and concise rules for transactions on behalf of the company. And the concept of significant transactions was introduced as a part of this self-enforcing model. But in fact, this concept initially, as I have already mentioned, protected shareholders, while the first Council directive of the European Union and all the subsequent legislation in this regard emphasized on protecting third parties, not the shareholders of the company, right? But the protection of third parties to make them sure that if they conclude a contract with a company, right, and the director of this company, in fact, will turn out to go beyond his powers, these third parties could be sure that this transaction will not be declared void. So this was the main philosophy, and this shows the great difference in these philosophies, right? What problems do we face in practice currently with regard to these two concepts, significant transactions and transactions involving conflict of interest? First of all, if we analyze significant transactions, as I have already mentioned, this concept stands for the interests of shareholders, but not third parties, as the directive does. And they cannot be applied automatically. So this concept brings a lot of transaction costs for the third parties. As a practicing lawyer, I can say that when we have the beginning of the financial year, all our counter-agents of our contracts, yes, our clients and other entities, they ask us to have these general meetings consent to conclude any contract during this financial year. And in fact, it is redundant. Otherwise, our clients ask us to show our financial report and they start analyzing it very, very carefully and so on and so on. But it all requires a lot of time, which is not very well for market functioning in whole. So, as I said, the concept of significant transaction is not very easy to apply. It cannot be applied automatically, and it requires third parties to consider a lot of specific details. Which details? What is the market value of a subject of a transaction which is going to be concluded? For example, during the war, we usually face the situation when naturally companies try to sell their goods at the lowered price because they cannot simply they cannot sell it, and they do not want to pay for the storage of these goods. They are interested in selling it even if the price is lower. But this is not a market value. So a transaction contains a price, but it is lower than a market value. And to know the market value, we need to refer to the professional expert who will estimate the market value, which is, which again requires some time. So it is uneasy to do. Then we also need to know what is the value of the company's assets according to the latest financial report. And it is also uneasy to find out. Yes, of course, all the companies have to give their financial report if the other party asks them to do so. But anyway, this is time, and this requires an expertise, and this can slow down the market circulation on the whole. And so in this resolution of Supreme Court, which you can see here from 2021, our Supreme Court pointed out at these issues, and in the end came to the conclusion that although the significant transaction was concluded beyond the powers of the director, it cannot be claimed void, because it will be unfair to do. Considering transactions which involve conflict of interests, again, this concept stands for the interests of shareholders, not for the interest of third parties. And again, our Supreme Court pointed out that these transactions are doubtful with regard to whether the transaction may be declared void only because of the absence of the general meetings or supervisory board's consent. So this is the first provision. It is also doubtful since these transactions do not clarify whether the terms of transaction and their fairness, market value, satisfaction of the company's interests, and other provisions shall be taken into account. In the end, our Supreme Court, in a case from 2022, came to the conclusion that in case law, we should take a nuanced approach, and the absence of a consent of the general meeting or the supervisory board does not automatically lead to the voidance of this transaction. We should also take into account whether the director who acted under the conflict of interests violated the interests of the company which it represented, he or she represented. The value of this transaction was a fair market value. If there were no burdensome terms in this transaction, so it was a clear, it was a fair, it was a balanced transaction, then there are no reasons to declare this void. The other provision which I would like also to analyze is the provisions of this Article 9 of the First Council Directive. So the transaction can be declared void if, as the directive says it, the third party, so the person with whom a company concluded a contract or a transaction, the third party knew or could not, in view of the circumstances, have been unaware of it. So what we have regarding this, we have Article 92 in the Civil Code of Ukraine, which provides the following rule. In relations with third parties, limitations of the powers of representation of a legal entity are not legally binding unless the legal entity proves that the third party knew or under all circumstances could not have been unaware of such restrictions. So from the first sight, this provision seems to be very much in common with the European one. But when we go deeper into the details, we will see that there are significant differences, in fact. Continue. Oh, thank you. Okay, so anyway, we have a rule comparable to Article 92 of Civil Code of Ukraine in the provisions of EMCA, European Model Companies Act, and also in Danish Companies Act. So we have much in common provisions in these laws, and so we can think that this is not so bad that we have a rule like that in Ukrainian legislation. And when we read the commentaries to the EMCA, we can see that this rule which is much in common with ours, with our Article 92, relies on the Rabobank versus Minderhound decision of the European Court of Justice. And what concludes this case of the CJU? It concludes that the provisions of the directive are not exhaustive and member states may complement them in their national legislation. So even though our Article 92 has some meaning, some other meaning in mind, which deviates from the provisions of directive, it is not a crime, let's say it. Because member states, although we are not a member state yet, but still we can deviate from this rule. But we should also mind that this case of the CJU is about transactions involving conflicts of interest. If we look carefully into this decision, we will see that there was a classic example when a director of one company was a shareholder in another company, and that is why the European Court of Justice said that it is okay that transactions of this kind are also restricted in the national legislation. And so if we take this narrow approach, and I think that we should take exactly narrow approach when interpreting our Article 92, then we can say a third party is deemed to have known about the limitations of powers of a director only where there is a conflict of interests. For example, when a director of this third party was a shareholder of the company with which this third party concluded a contract or something like that. But what we see in practice of Ukrainian courts, first of all, we have the provision in our case law that third party is considered to have known about the limitations of powers if it acted in bad faith or unreasonably considering the terms of the transaction and considering the market value of the subject of this transaction, etc. And this is a very widespread opinion, I should say. And when we analyze it carefully, it is quite doubtful whether it is correct because it seems to deviate from the general plot of this article. So the article says when the third party knew or could not have been unaware of the limitations of powers, while when a third party acts in bad faith or acts unreasonably, this means that this does not automatically mean that this third party was aware or could not have been unaware of it. It only means that the third party acted unreasonably or in bad faith. Also, we have the word in third party, knew or should have known, should be interpreted, in fact, broadly. A third party is considered to be aware of these limitations in the registry. Right? Mentioning about the limitations of powers of a director in a state registry, then, okay, we can presume that, yes, third parties can look into the registry and see these limitations. But in practice, it doesn't work this way because not all the limitations are usually disclosed in the state registry, because our registrars, they are not obliged to, introduce, I should say, they are not obliged to put all the limitations of powers which are contained in the statute and to put them into the registry. They are not obliged to do this by the statute. The other provision is that if a transaction says that the director of a company acts according to the statute, it may be presumed that the third party has read the statute and could find out about limitations of the powers of this director. So I think that in foreign practice, it also works in the same way. When we, in the preamble to the contract, say that, for example, limited liability company, I don't know, the son on whose become acts the director, and the director acts according to the statute. So this is a very standard phrase, and our courts interpret it in a way that if it is mentioned something like that, then the third party, which is the other party to this contract, is presumed to have known about these limitations. However, it is also very doubtful why should this presumption work this way. And we should also remember that the first Council directive, I will go back to the first slide. The first Council directive says in many phrases that the limits of the powers arising under the statutes anyway
Excuse me, because I was interrupted. Thank you. Thank you for your report. And now I would like to invite to a report our next participant from Czech Republic, Dr. Vosičková Lucia. Please, the floor is yours.
I'm sorry, thank you, Alexandre, and good afternoon to everyone. My topic is Czech Business Corporations Act and need for defining a new type of entities. Yes, I know there are also Czech participants. The legal entities in Czech Republic are defined in civil code as an organized body which the law stipulates as having legal personality or whose legal personality is recognized by law regardless of the object of its activity. Such entity may have rights and obligations that are consistent with its legal nature, and there are few types of entities, like we are dividing them into private law corporations, of course, associations which are regulated under the civil code, commercial corporations which are regulated under the Business Corporations Act, and also other which are, for example, foundations or mixed bodies or public legal entities. Anyway, all of them have some obligatory requirements from the regulation which they are regulated under. The new challenges comes with non-unification, let's say, of corporations within Europe, because as you all know, except for European company, the Societas Europea and European Cooperative Society, which are still rather rare in the EU member states, but there are still obligatory provisions which should be used for different activities under the EU regulation. A good example would be a directive 2018 2001 of the European Parliament and of the Council on the promotion of the use of energy from renewable resources from 2018, and Directive number 2019-9 of the Parliament and Council on common rules for the internal market for electricity. Both of these directives are defining the legitimate group of actors which are allowed, let's say, or establish and also operate the setup powers and influence within the energy communities. They are forbidden some corporations or some other actors to have such influence or such powers within such community. And they are also, but that's not that important or that strict. They are also defining the purpose of such energy communities, but the definition is more soft. They are only saying that the community has to provide environmental, social, economic benefits, and so on for the shareholders and the local areas. So they does not restrict the use of surpluses nor the internal dividend or payment schemes. During these two directives were implemented into Czech law by amendment of Energy Act, and during the legislative procedure, the question of limitation of the entities which could be used for establishment of the energy communities were discussed between regulatory experts. Actually, two solutions were proposed. The first was to use form of associations or limited liability companies, or second one, to amend the Business Corporation Acts of a new entity type, which would allow the restriction given by both of the directives, the directive on the promotion of the use of energy and the directive on the common rules for the internal market for electricity. Actually, none of them was taken, and the third option was agreed, and the amendment to the Energy Act finally keeps silent on this matter. We can assume actually that such fact can be caused by time pressure the Czech legislator was facing during the process, because the deadline to implement both of the directives were quite soon, let's say. We may see here that our legal and our forms of legal entities are not able to face the EU regulations and the obligatory EU regulations that are in force or are approved on the level of EU. If we compare the different types of entities within EU, we may see that, for example, Czech Republic has only like really limited number, let's say, of legal firms. There are many of the EU legislations that are having like much more type of legal entities, and without unification of another type of entities, we are going to face such troubles. We may see that in this case, that the main restrictions or the main problems which our type of entities are faces are they limitation to the openness of the membership, because the EU regulation, for example, requests only some type of entities who have the membership or some type of person above legal or nature, which is not possible under Czech law, or it's possible but by some other means. What is also like second problematic point, or what shall be changed or what shall be discussed, are the restrictions to voting rights and effective control. Because also not only that this is like big discussion or big regulatory framework for voting rights, but also the case law in this regards, it's quite huge, and it cannot be passed, let's say, on the new type of entities or a new type of, let's say, renewable energy communities. The next point, or the next most important problem, would be the restrictions to the membership. So the other way around, the memberships shall be restricted, which would be problematic from the Czech law, let's say, from the Act of Corporate Czech Corporate Act. That's all from my side. If you would have any questions, I'm happy to discuss.
Thank you, dear Lucia, for your report. According to our rules, we have a discussion at the end of this second part of the conference. First of all, we hear the next reports, the reports of other participants, other colleagues, and afterwards there will be a discussion. So thank you for your report, and please, if you have a possibility, please remain in Zoom. I think maximum half an hour, because there are still two reports, Dr. Tadzhibava and Dr. Mizerski. And after that, there will be already a discussion. Thank you once more,
Alexander.
and I invite to have a speech Dr. Tadzhibava. Dear Mahsuda, please, the floor is yours. Your microphone is switched off. Just switched off. Microphone.
And thank you, Alexander. And good afternoon, distinguished guests, colleagues, and fellow professionals. It's an honor to be here to discuss wonderful topics. It's increasingly relevant in today's fast evolving corporate world, like corporate legal sandboxes. In today's fast changing world, traditional legal rules can sometimes struggle to keep up with the new corporate innovations. This is where corporate legal sandboxes help, and they provide a safe, regulated space where companies can test new ideas and business models, and under government supervision, allowing innovation while ensuring compliance with the law. And today, I will explore how legal sandboxes function as a pathway to evolving legal regulation for innovative corporate activities. And I will also examine the European Union's experience with the legal sandboxes and analyze the opportunities for adapting such frameworks to the CIS regions. And understanding the corporate legal sandboxes, what are the regulatory sandboxes? What are legal sandboxes? Sandbox is a special legal setup for testing new innovative projects, and it allows businesses to skip certain rules that might slow down or block innovation, making it easier for them to experiment and develop new ideas without the usual regulatory restrictions. And why are these legal sandboxes are needed? New technologies and services are always emerging, making production, communication, and everyday life easier. But laws often cannot keep up with these fast changes, meaning some innovation might not fit within the existing legal framework for a long time. By using this kind of legal sandboxes, companies and government regulators can test these new products and services in a safe environment without worrying about breaking current rules or laws. If the testing goes well, this innovation can later be officially launched and legally and safely accepted in the market. Well, actually, regulatory sandboxes, legal sandboxes, are used worldwide. The first sandboxes was launched in the United Kingdom in 2016. It supported innovation in the financial sector since many countries have adopted similar models like the United States of America, Australia, Singapore, United Arab Emirates, Malaysia, Thailand, Indonesia, Canada, and etc. In which areas are regulatory sandboxes are applied? Mostly sandboxes cover sectors such as medical sector, pharmaceutical industries, transportation, including unmanned vehicles, e-learning, financial markets, e-commerce, and industry construction and public service. And if I talk how legal sandboxes promote innovation, they provide a space where companies can innovate, experiment, and launch new products without the risk of immediately violating existing regulations. And there are so many benefits to companies and regulators. It reduces legal uncertainty for regulators, for investors. It allows real-time monitoring and understanding of new technologies and business models. There are several ways in which regulators governments can around the world are seeking to benefit from regulatory sandboxes. Here are some of the most commonly cited benefits. It fosters innovation. Sandboxes allow companies to try new ideas safely, encouraging creativity without breaking rules. And it fasts market access. The simpler process help new solutions reach customer quicker, and it makes lower cost for startups. They reduce the cost of navigating complicated regulations, saving time and money, and etc. It improves consumer protection. Sandbox includes safeguards to protect consumer rights. And regulators get hands-on experience with new technologies, helping them create future-ready policies. And stakeholders also innovators, regulators, and others to develop better, widely accepted rules, and the sandbox promote communication between them. And a supportive regulatory environment signals openness to innovation, drawing investors and venture capitals. Controlled trials identify to solve potential issues early on, and the media attention as well. Sandboxes often attract media, boosting visibility and trust, which can help participants build a positive reputation and attract partners on investors. And the use of legal sandbox, while innovative, has raised several concerns. Critics argue that these experimental environments could lead to lower regulatory standards as regulators try to attract new business, potentially weaken consumer protection. And particularly the financial sector may see risk of safeguards or are compromised. Additionally, there are some worries that artificial intelligence testing in sandboxes might allow companies to sidestep data protection rules, and inconsistent regulations across different countries in the European Union could harm market cohesion and signal true innovation. There are worries about how legal sandbox might misuse it. Regulators might lower rules, attract business, weakening consumer protection, especially in fintech, and focusing too much on innovation and could reduce public and consumer safeguards. And testing artificial intelligence in sandboxes may let companies avoid data protection rules, and different sandbox rules across European Union countries might create inconsistent standards, harming the single market and slowing through innovation. And the approach to legal sandboxes, here are in this slide, we can see that how Norway and the United Kingdom have taken significant steps in adapting regulatory sandboxes to advance innovation. And Norway's sandbox focuses on providing guidance on personal data protection for both private and public sectors, While the United Kingdom sandbox explores technologies like voice biometrics and facial recognition and addressing related data protection concerns. And here we can see that European Commission Artificial Intelligence Act proposal, and this is one of the most important acts in European Union, and it introduced in April 2021, includes the concept of artificial intelligence regulatory sandboxes designed to promote innovation in artificial intelligence. And these sandboxes will provide a controlled space for companies to experiment with artificial intelligence technologies, products. And the main goals is to support artificial intelligence innovation by allowing controlled experimentation. And the proposal calls for coordinated national artificial intelligence sandboxes, but their establishment is not mandatory for member states, for all member of the states. And participants in the sandboxes will not be exempt from liability under European Union or member state laws for any harm caused during the experimentation. The proposal details the condition and process for participants in the sandboxes, including eligibility and the rights for obligation for participants. And the Act aims to clarify how artificial intelligence regulations interact with the existing data protection laws, requiring coordination with National Data Protection Authority. And the Digital Europe program supports the creation of testing facilities to aid in the development of artificial intelligence system. And the proposal aims to create a balance approach to innovation and regulation, but it also highlights the need for clarity and consistency across the European Union. And the 2021 and 2027 Digital Europe program plans to create testing and experimentation facilities across the European Union. These facilities will help companies test artificial intelligence products and services in a safe environment, ensure they meet safety rules. And TFS will also help develop guidelines to encourage companies and public institutions to follow artificial regulation voluntarily. And transfer opportunities to CIS countries. Several CIS countries are embracing regulatory sandboxes to foster fintech and technological innovation. Kazakhstan's National Bank lists its fintech sandbox, helping startups test products while following local regulation. And Ukrainians, I also learned Ukrainians practice and Ukrainian sandbox under the National Securities and Stock Market Commission supports fintech and digital assets. And similarly, Belarus, Armenia, and Kyrgyzstan are exploring or implementing sandboxes to encouraging fintech's growth while ensuring regulatory oversight. However, we should talk about challenges when implementing legal sandboxes. This kind of challenges may arise. First, there is the need to build institutional trust, ensuring that participants comply with the laws and do not exploit related regulations. And investors and consumer protection are essential, and safeguard must be maintained even in an experimental environment. Strong oversight mechanisms are crucial to prevent potential misuse and ensure accountability. And effective collaboration between governments, regulators, and the private sector is necessary to balance innovation with the legal and ethical obligation, ensuring that regulatory flexibility doesn't compromise public safety or make stability. And in conclusion, legal sandboxes acts as a bridge between strict regulations and the need for innovation, just as a child sandbox offers a safe space to play and experiment, and legal sandboxes give companies room to develop new technologies and business models without immediately having to comply with every regulation. And by offering flexibility, they help ensure that the laws can adapt to the fast-paced changes of today's world. And these frameworks are proving valuable in Europe and beyond, providing the key lessons to CIS countries looking to integrate similar regulatory models for innovation and economic growth. And thank you. Thank you all of your attention and participation. And it was a pleasure to share my insight, my ideas with such a knowledgeable and engaged audience. And I'm grateful for the opportunity to be part of this conference. And I look forward to staying connected as we continue to navigate the existing challenges ahead. Thank you once again.
Thank you. Thank you very much for your report. And now I would like to invite for the next report our colleague from Silesian University, Dr. Mizerski. Dear Dominique, please, the floor is yours.
Thank you. Let me only show the presentation. Second. Okay. I have to log. Give me a second. Okay, I have to, quit the meeting for 1 second, and I will join in 1 minute because I have to only change something in my settings.
Okay, no problem.
And then I will join you.
No
Okay,
problem.
so
We are waiting.
Okay.
Okay. Just a moment. Our colleague from Silesian University, as I understand, if I understand correctly, should reload his computer because something has happened with his slides, with his presentation. That's why just a moment, and he comes back to our session, to our conference in 1, maximum 2 minutes.
Okay, now I hope that it will work, and I see probably that it works. Okay, can you confirm that you see the presentation?
Yes, we confirm we see the presentation.
Okay, and for example, can you see that that I changing the slides or no?
Yes, they are changed.
Yeah. Okay, great. So once again, for my problem with the screen, thank you very much for the invitation. Thank you very much for giving me this opportunity to show my short presentation about the related party transaction regime toward control over intra-group transaction. Now, firstly, I would like to start what is the related party. I mean that, to describe the risk associated with the related party transactions. And what are they? Related party transactions are fundamental, particularly for the operation of the group of companies, because development of the relation between the group members, particularly via concluding such transaction often determine the purpose of such group. So when we have group of companies, it's absolutely essential. It's absolutely important for such groups members to conclude transaction between them, and concluding such transaction determine the often purpose of such group. But however, it could happen situation where such transaction could create the disappropriate and unjustified advantage of the strategic shareholders. So in this case, such transaction can cause damage, can cause damages for the minority shareholders and also the assets of the company, because the most important assets can be transferred to majority shareholders, and it can cause the harm for the companies itself and also for their shareholders, particularly the minority shareholders. So European legislation identified this problem, and in Directive 2017/828, the European lawmaker imposed to member state obligation to introduce to implement related party transaction regime to their legal system. And in general, the member states were obliged to introduce two obligations about concluding related party transactions. So in the case of related party transactions, the company have to fulfill the information obligation. So in general, to announce the conclusion of such conclusion of such transaction, and also to procure that the internal body of the company will give a consent to conclusion of such transaction. So there are these two elementary obligations. And the third one, the not obligatory, is to prepare the fairness opinion about the transaction by the independent third parties. But it's because it's not obligatory. Probably, if I remember correctly, only 2 member states introduced such regime. But it's not the related party transaction regime arising from the implementation of such directive. It's not the only one related party transaction regime in Polish law system. The second regime is introduced by Polish lawmaker on its own. It is the only own initiative of the Polish lawmaker, and I want to compare such two regimes and prove that in general it caused a lot of problem to companies, particularly in respect of the conclusion of such transaction between the companies to whom these two regimes apply. So let's start from the subjective scope. So the first regime, this regime arising from the implementation of directive applied to companies having their registered office in the territory of the Poland, at least one share of which they have been admitted to trading on regulated market. But regarding the subjective scope of Commercial Companies Code, this regime under this Commercial Companies Code applied to all joint stock companies, with 2 exemptions. One exemption to these companies whose shares are trading on the regulated market, because to this company the second regime, the regime arising from the Act on Public Offering, apply, and also the regime of Commercial Companies Code do not cover the companies belonging to the group of companies, but the group of companies in the legal interpretation, in the legal definition, it still applied to the factual group of companies. So this is the subjective scope. So in general, every joint stock companies in the definition of Polish law have to comply with such two regimes. About the definition of the related party, because this we have to also determine what related party means. So under the Act on Public Offering, the related party is determined by the list described in International Accounting Standard number 24. And about the Commercial Companies Code, so about the second regime, it covers only parent companies, subsidiary and affiliated companies. So, for example, under the Commercial Companies Code, the majority shareholder or directors of the companies, they are not qualified. They are not qualified as a related party under this regime. Also regarding some words about the about definition of the material transaction, because these two related party transaction regimes do not apply to all those transactions, but only to these transactions which are qualified as material transactions. So the definition of material transaction under the Act on Public Offering is that such transaction can be qualified as material transaction if only the value of such transaction exceeds the 5% of the total assets determined on the basis of the last approved company's financial statement. So this is the definition of material transaction under provision of Act on Public Offering. The definition under provision of Commercial Companies Code is very similar, but it changed. The provision contain different percent, because this is the 10%. So much higher in respect of such transaction. And also, I would like to compare the definition of the transaction between the Act on Public Offering and Commercial Companies Code, and this is quite awkward and vague, but unfortunately, neither the provision of Act on Public Offering nor the provision of Commercial Companies Code do not contain such transactions. So it causes a lot of difficulties with interpretation of such definition, because, for example, Polish law rather refers to the definition of legal acts, to definition of agreements, contracts, something like that, and the definition of transaction is rather unknown under the Polish law. So there, in this respect, in this problem of defining the transaction, there are two points of view about it. There are two different, if I can say it. One refers that the term of transaction should be interpreted as it is defined in International Accounting Standard 24. So it should be determined. Transaction should be determined as transfer of resources, or services, or obligation, regardless the price is charged. So this is the one view, and the second view, minority view, determines transaction by the terminology known by Polish law. So in general, the second view refers that the transaction is the agreement, is the contract, legal action when the related party acquire the property, movable or immovable, or assume the obligation. But for example, for me, the best one is the first view, so referring to the definition of the transaction into the International Accounting Standard 24. Let's also have a look about the comparison of information and rectification obligation. Under the Act on Public Offering, as I described in the beginning, there are two obligations. First of all, the company have to publish information about the conclusion of the transaction at the time of the conclusion of the transaction, and such information is published on company's website. And rectification obligation, so simply the obligation to approve, to give a consent to conclusion of such transaction, and the role model of such competence belong to the supervisory board. So in general, supervisory board giving their consent to conclusion of the material transaction by the company. About the obligation under Commercial Companies Code, so the second regime, there are no information obligation. There is only the rectification obligation, and it's based on the same rule as a rectification obligation under the provision of Act of Public Offering. So it's the same. So I will skip it. And now I would like to draw your attention about the exemption from these two regimes and prove that it caused a lot of difficulties to the companies belonging to the group of companies. So under the exemptions under the Act of Public Offering, they refer to 4 exemptions. Fair exemption, which exclude obligation of the related party transaction regime concern transaction concluded on market terms, which are part of ordinary operation of the company. So pretty big excuse. The second, transaction concluded by the company with its subsidiary, but only in the case if the company is the sole shareholder of the subsidiary. So it only refers to the subsidiary directly controlled by the company. So, for example, the transaction between company and subsidiary, which is controlled not directly, it's not qualified under this exemption. Also, the provision of Act on Public Offering, they do not apply to transactions related to the payment of the remuneration of the members of the management board and supervisory board, if such remuneration are paid under the remuneration policy, and also transaction regarding banks subject to the compulsory restructuring. And the exemption under the provision commercial code, it's very easy to tell about them, because there are no such exemptions. Such exemption under the provision of Commercial Companies Code can be introduced, can be passed under the provision of Act they can be introduced into the company's articles of association, but it's necessary firstly to change the articles of association. So this is the problem. But if we are referring to the public offering or the Commercial Companies Code in general, we see that there are no big and broad exemption concerning the transaction between the group members. And in practice, it caused a lot of difficulties about such companies, about such group, because every time if they want to conclude the material transaction, they have to comply with this obligation. And for example, of course, non-compliance with the information obligation do not cause any, let's say, important legal effects to such transaction. But for example, concluding a transaction without consent of the supervisory board cause the invalidity of the transaction. So this is quite big consequences in the case of conclusion of such transaction without the consent. So in the perspective of the group of companies, particularly the rectification obligation caused a lot of difficulties, and also it caused a lot of difficulty to identify whether the material transaction is subject to such regime or no. So in general, the situation of the group of companies in Poland in perspective of these two regimes, it's not very clear, and it caused a lot of, I will repeat myself, but caused a lot of difficulties to comply with these two regimes. And for me, it's everything. Thank you very much for the attention. In case of any question, feel free to ask me. I will be happy to answer. Thank you very much.
Thank you very much for your report. I think that we may begin our discussion concerning the reports of the second half of our English section of the conference. Because there is a lack of time, my report will be presented in our joint collection of articles. So I would like to encourage all the participants to the discussion of the conference's reports, and if I could let me to start, for example, I would like to ask Dr. Lucia concerning the Czech system of companies. Dear Lucia, do you hear us? Dr. Vasichkova?
Sure, I'm hearing you. I didn't recognize my name, sorry.
Excuse me if I pronounce some names
Yeah, sorry, I
incorrectly.
thought it's surname of someone. I'm sorry for that.
Excuse me, because not so perfect in Czech pronunciation. So excuse me once more. My question concerns the Czech system of companies, and what is the trend in Czech legislation, maybe in Czech legal science, law science concerning the amendments to the system of of companies in Czech Republic. I mean, for example, in Slovakia and in Poland, there is this new type, simple joint stock company. Not so long ago, in Austria, there was implemented flexible company, FlexCo, so-called. Just several months ago, it was adopted. And what about the Czech legal system and the Czech system of companies? Thank you.
Thank you. I think the situation I was talking about regarding the implementation of the two new directives of the EU was the great opportunity, let's say, for Czech legislator to more, let's say, involved, because such problems will rising up in the future. But unfortunately, and as I said, probably or most probably because of the lack of time, there were no changes or no establishment of the new type of the company, even though that some more flexible type of company would be really beneficial to be implemented. So the let's say the proposals or the experience is more rather still on the professional discussion, let's say, that than in the. Can you hear me? Yeah, okay. Rather in the
yes, we hear you. Everything is okay with connection.
No, perfect. So I just wanted to say that such discussions are rather on the level of the professional discussions than in the proposals of the legislators. And it's a pity that such opportunity was not taken, because some more flexible type of company would be beneficial for our system. But in my opinion, personal opinion, it will come sooner or later, because the conditions of the EU directives are pushing us to establish such form. So it's, in my opinion, a matter of time.
Okay, thank you. Thank you for your answer.
Thank you.
Because really, that is a very interesting issue concerning these novels and this draft of novelization of Ukrainian civil code concerning changes in our commercial code. That's why experience of Czech Republic, experience of Poland is very necessary for us in all of these aspects, system of companies, related parties and transactions. That's always really interesting for us exactly at this moment. And of course, the experience of Uzbekistan. And the next question in this context, dear Mahsuda, Dr. Mahsuda, do you hear us?
Yes, I'm hearing you.
You have mentioned about sandboxes in your report, and you researched the experience of implementing these EU directives in the legislations of post-Soviet countries, so-called CIS countries, and in Uzbekistan. In your opinion, in comparison among post-Soviet states, which of them are more oriented on EU legal institutions and legal concept, and which of them are not so oriented and not maybe plan in the future to implement these directives, these legal concepts concerning innovative corporate activities? Thank you.
Thank you so much. This is a very interesting question. Before the learning of the CIS countries' progress, I learned briefly what's going on in the world, and I studied what about in European unions, what about in Japan. It's very flourished in Japan as well, and it is very, it's important to mention that the Kyrgyzstan and Kazakhstan has a very great leadership in this area, and they take European Union models, and Kazakhstan's national bank leads its fintech sandbox and helps startups test products and follows local regulations as well. And Kyrgyzstan are also exploring and implementing sandboxes to encourage fintech's growth while ensuring regulatory oversight as well. And these two countries are widely used European Union practice, European Union's models. And I think in the future, unfortunately, there are some lack of knowledge, lack of practice in Uzbekistan in this case. Uzbekistan also tries to develop its open sandbox as a part of its digital transformation efforts, guided with a central bank. And however, we can see that Kazakhstan and Kyrgyzstan are widely used European Union's models and practice.
Okay, thank you for your answer. And maybe some other questions, dear colleagues. I encourage you to have a discussion concerning the reports. Okay, in such case, maybe the last question concerning the report of Dr. Mizerski. Dear Dominique, you have mentioned that, in fact, sometimes, if I have understood correctly, there are different definitions of a word transaction in two legal acts in Poland. There is difference in act of public offering and commercial code of companies in Poland. And in such case, what of this document is applied in practice? And in your opinion, which of them is more favorable in practice?
But speaking generally about these two regimes, or about only this percentage of of this material transaction definition, because I don't know whether I understood correctly.
Just in case of this definition. So if there are different approaches for the definition of transaction, if there are different approaches in between two legal acts, which of them is more favorable for, on your opinion, for the economy and court practice? How is the court practice?
So probably also, I mean that speaking on the theoretical ground and practical ground, probably this regime under Act on Public Offering is better. I mean that Of course, it's vague and not clear, but in general, due to this, due to these exemptions, due to that, it was also passed earlier that that the regime of under the Commercial Companies Code. I guess that the first one, I mean that the regime under Act of Public Offering is better and more clear than the second one.
Okay, thank you. Thank you.
Thank you
for
very
the
much.
answer. Maybe some other questions. So if there are no questions, I would like to thank all the participants here. At this moment, we have exactly representatives from every state. Two from Ukraine, Dr. Filatova Belos and me, and from Uzbekistan, from Poland, Czech Republic, and I hope that in future such our meetings, such conferences will be regular. Maybe again at the university in Ivano-Frankivsk, or maybe at your universities. And I hope that this today conference was an opportunity for you to make contacts, to hear something interesting in the development of our company law legislations of our countries. And dear colleagues, I wish you all the best and to the next meetings in the future.
Thank you very much.
Thank you so much.
Thank you so much.
Thank you.
Bye bye.